How's it going, guys? I'm back. I'm making this video because when I was doing legal research I came across this little law that said that when you are charged with violating California Vehicle Code 14601.1a, or I believe California Vehicle Code 12500, which is driving on a suspended license, it is an infraction and not a misdemeanor. However, we all know that they charge you with a misdemeanor in order to impound your car and take you to jail. Surprise, surprise. However, the only way that the prosecution can proceed with driving on a suspended license, now this doesn't apply, of course, if you had a DUI and your license got suspended. Sorry, but you're screwed. This only applies if you failed to appear or didn't pay or something to that effect. Now, the only way the prosecutor can proceed with this as a misdemeanor is if the defendant in writing elects for the prosecutor to treat this infraction as a misdemeanor in order for the defendant to be able to have a public defender and a trial by jury. Now, who the hell says please put this as a misdemeanor so that I have to pay to get my car out that you guys stole, and so that I can possibly face jail time? Nobody does. But of course we all know what they do, and that's whatever they want. Now, I believe they also do this because that way it's a psychological game. When they say, well, I'll cut you a break and I'll reduce it to an infraction if you plead guilty. So, of course, the person's going to say, well, thank you, Your Honor, you're such a nice person. When in fact, if they would have known it was an infraction to begin with, they would have probably fought it from there, you know. But anyways, I wanted to make this video so you guys could be aware that this is the kind of scam that these courts are doing out here in California. And I made this motion, as a matter of fact, for one of my cases, and it got reduced. And the judge asked me where I got this information, and I said, Your Honor, I do legal research. And so he just smiled and said, okay, that's good, that's good. So, I mean, it worked for me. But even if they decide not to have this reduced and say, well, no, this is not an infraction, this is a misdemeanor, it's up to the DA to, you know, change it. No, no, no. I would do what's called a writ of prohibition or a writ of mandate, you know, so that they can go ahead and make them change it to an infraction or prohibit them from having this as a misdemeanor. So, hopefully you guys enjoyed this video. If you guys ever want to donate for this cause, of course, I will be more than glad to send you an email with this sample motion that I made for myself. Of course, this is for educational purposes only, and you guys can go ahead and have a great day.